Hey, welcome to the deep dive. Today we're doing exactly what it says on the tin, diving deep into a stack of information, specifically excerpts from the Electricity Act of 2003, along with its amendments.
Yep, a pretty foundational piece of law.
Think of this as your cheat sheet to understanding something that, well, literally powers everything around us in India.
Absolutely. Our mission, to pull out the key stuff, the bits that really matter.
And lay it out for you in a way that's clear and hopefully actually interesting. No law degree needed, we promise.
None at all. We're aiming for a solid grasp of the core framework.
Mm-hmm.
The essential definitions, how electricity gets generated, moved around.
And how it ends up at your place, the who, what, and how behind flicking that switch.
Yeah.
You ready to plug in?
Let's do it.
Okay, so let's get down to brass tacks, starting with the absolute foundation definitions. Now, I know you're thinking definitions, seriously.
Yeah, but you got to start here. It's like the rules of the game, right?
Exactly. First up, conservation. You probably think save energy, turn off lights, that kind of thing.
And yeah, that's part of it. But the Act is a bit more specific. It defines it as any drop in electricity use because we've gotten smarter. Either more efficient supply or more efficient use.
Ah, so efficiency is the key word, like smart grids, better appliances.
Precisely. Getting the same result, or better, with less juice. Then there's consumer. Seems simple, us, right?
You and me using the power.
But the legal definition is pretty broad. It's anyone getting electricity for their own use. Doesn't matter if it's from a big company, the government, or someone else allowed to supply it.
Okay, own use is key.
And here's a little twist.
Oh.
Even if your place is connected, but you're not actually drawing power at that moment, you're still technically a consumer under the Act.
Really? So if my house is wired up, even if I'm away on holiday, I'm still a consumer?
As long as the premises are connected, yep, you're in the club.
Huh, okay. Good to know. Now, let's talk hardware. Infrastructure, we've got distributing main, sounds important, like a main artery.
You're on the right track. Think of it as the last major power line in your neighborhood before it branches off to individual places.
Right.
It's the part of a main supply line where a service line, that's the wire to your house, connects or is intended to connect.
Okay, so the distributing main is the street, the service line is my driveway. Got it.
Nice analogy. And then there's the distribution system. That's got to be the whole local network, right?
Yeah, the whole setup in my area.
Exactly. That's the whole shebang. Everything between the big high-voltage transmission lines or maybe a local generator and the point where it connects to your property. All the local wires, transformers, the works.
Right. And speaking of wires, the definition of electric line, it's more than just the metal wire, isn't it?
Oh, yeah, much more. It's not just the conductor carrying the current. It's also everything holding it up, the towers, the poles, insulators, you name it.
So those huge lattice towers you see marching across the fields, the whole thing is the electric line.
The whole structure. Yep.
Yeah.
It's a package deal in the eyes of the Act.
Okay, that paints a bigger picture. Now, zooming out again, transmission lines. These are the power superhighways, yeah, moving electricity long distances.
Exactly. And the Act spells out a few key types. One, any movement of power between states. That's transmission.
Interstate, got it.
Two, even if power goes through an intervening state to get somewhere else, that whole journey counts. Even the bits within the state is just passing through.
Okay, so pass-through counts too.
And third, any movement within a state, but using the systems controlled by the big national player, the central transmission utility. We'll get to them later.
Right, so basically any serious long-haul travel or using the main national grid, that's transmission.
You got it. Power's grand tour. Now, a simpler related term is just main. Feels like any generic power line.
Pretty much. A main is just any electric supply line used or intended to be used for supplying electricity. It's a general term.
Okay. We also saw member capital M for commissions and tribunals. That's just anyone on the board, including the boss, the chairperson. Spot on. It's the umbrella term for anyone holding a seat on those regulatory bodies we'll be talking about.
Then the National Electricity Plan. Sounds like the master strategy. The big picture.
It is. It's the government's blueprint for how India's electricity sector should develop. Officially notified, all very formal. It's the vision document.
And making sure all that planned power gets where it needs to go efficiently. That's the National Load Dispatch Center. What's their role?
Think air traffic control, but for electrons flowing across the country. They optimize the scheduling, the dispatch between all the different regions, making sure the right power goes to the right place at the right time.
Like conducting a national power orchestra. Makes sense.
Exactly. A crucial job.
Now, notification. Sounds like lawyers speak for making it official.
You nailed it. It just means published in the official Gazette, the government's formal announcement page, basically.
Okay, now here's a term you hear a lot: open access. What does the Act actually mean by that?
Open access is basically the rule that certain players, other power companies, big consumers, generators, have the right to use the existing power lines. Non-discriminatory use.
So they can use the transmission lines or the local distribution lines.
Both. They have to pay for it, obviously, following the rules set by the commissions. But they can't just be blocked unfairly. It's about opening up the grid, fostering competition.
Letting more players onto the power highways. Got it. What about overhead line? Seems obvious. Wire in the air. Any catch?
Mostly straightforward. An electric line above ground, out of the open. The only real carve-out is for the live rails powering electric trains or trams.
Ah, okay, so train power lines are different.
They've got their own rules. So yeah, wires on poles, generally overhead line, unless it's for a train.
Makes sense. And person. Simple word, but legal definitions can be wide, right?
Oh, absolutely. Here, person isn't just an individual. It includes companies, any kind of corporate body, associations, even artificial juridical persons like trusts or universities.
So pretty much any entity involved in electricity, from Joe Public to a massive corporation.
Exactly. They're all persons here. Now, power system sounds like the big umbrella term for everything.
The whole kit and caboodle.
You got it. Generation, transmission, distribution, supply. The Act even says it could be just one of those, or any mix. It's the whole interconnected web.
Then we circle back to service line. Looks like a couple of scenarios.
Yep. It's the final link. Scenario 1. Wire from the distributing main or the power company's premises straight to one customer. Single connection.
Okay.
Scenario 2. A line from the distributing main serving a group of consumers who are all on the same property, or maybe adjoining properties, fed from that single point.
Like an apartment block getting power from one main connection.
Exactly like that. That's a service line too.
Clears that up. What about specified? That word pops up everywhere in laws.
It's basically a signpost. When you see specified, it means the nitty-gritty details, the standards, procedures, numbers aren't in the Act itself, but in the regulations made later by the appropriate commission or the Central Electricity Authority.
So the Act gives the outline, the regulations fill in the blanks.
You got it. Then, standalone system. Sounds like off-grid, like solar panels in the Himalayas.
Pretty much. It's a self-contained system, generates and distributes power in a specific area, but not connected to the main grid. Think remote villages, maybe islands.
Power islands. Makes sense. Now, utility, common word, but the Act's angle. Here, utility means the physical stuff, the assets. Electric lines, power plants, land, buildings, equipment, all the tangible things belonging to generating companies or licensees that make the system work.
The physical backbone. Got it. Then wheeling. Sounds like dealing cards or maybe luggage. Not in the power context, I assume.
No suitcases. Wheeling is when someone uses the transmission or distribution system owned by a licensee to move their own electricity.
Ah, so using someone else's wires to move your power.
Exactly. You pay a fee, a toll, basically, set by the commissions to use that infrastructure. Like renting space on the power grid highway.
Right. Makes sense. And finally, works. Sounds incredibly broad.
It is, intentionally so. Works covers basically anything and everything needed to transmit, distribute, or supply electricity to the public. Lines, buildings, plants, machinery, apparatus. The whole collection of necessary gear to get the job done under a license.
Okay, definition marathon complete. But crucial, as you said, now we know the language. Let's talk about actually making the electricity. Generation. Who gets to do it? What are the rules?
Right. And here's where it gets interesting. The Act actually lets generating companies set up and run power plants without a license.
Really? No license needed?
Well, there's a condition. They have to meet the technical standards for connecting to the grid. But yeah, if you meet the standards, you can build and operate. It's meant to encourage generation.
That seems like a big deal. Opens things up. But I bet there are special rules for hydroelectric power. Dams, rivers, that's complicated stuff.
Absolutely. Hydro is special. If a company wants to build a hydro project and the cost is above a certain threshold set by the government.
A big project then.
Right. They have to prepare a detailed scheme, a plan, and get what's called concurrence, basically. Approval from the Central Electricity Authority.
And I'm guessing the authority doesn't just rubber stamp these.
Not at all. They have to look really carefully at a couple of things. First, will the project mess up the best long-term development of that river for power? But also, crucially, how does it affect other uses? Drinking water, irrigation, navigation, flood control. other public needs.
So a balancing act, power versus other water uses.
Exactly. They have to consult with state and central governments, other agencies, to find the optimal spot for the dam, considering everything. And second, they check the dam's design and safety. Got to meet the norms. That's critical.
Absolutely critical with dams. What about coordinating with existing river projects? Ones that might already be doing irrigation or flood control?
Good point. The Act emphasizes coordination. If there's already a multi-purpose project, any new hydro generator and the state government must work with the folks running the existing scheme, especially if their operations are linked. It's about everyone playing nice in the same sandbox, or rather, river basin.
Makes sense. Avoid conflicts, maximize benefits. Okay, let's switch tracks to captive generation. Sounds like power made for yourself, like a factory's own plant.
Precisely. The Act lets a person remember that broad definition. Build, maintain, and operate their own power plant, a captive plant, plus dedicated lines to get that power to their own facilities without needing a specific license under this Act.
So big industry can basically make its own power.
Often happens. They want reliability, maybe cost savings. It's like having your own power tap.
But are there strings attached? Any obligations for these captive generators?
Couple of important ones. They have to submit technical details about their plant to the appropriate commission, could be central or state, and to the Central Electricity Authority.
Keep the authorities informed.
Right. And importantly, if they generate more power than they need and want to send the surplus to the grid, they have to coordinate with the relevant transmission utility, central or state, to make sure it's done safely and properly.
Can't just dump excess power onto the grid willy-nilly.
Exactly. Coordination is key. Now, the Act also gives the government power to direct generating companies in extraordinary circumstances.
That sounds dramatic.
Yeah, what qualifies as extraordinary?
Think genuine crises. A threat to national security, major public order breakdown, a natural disaster like a huge flood or earthquake, or anything else the government decides is vital for the public interest.
Real emergencies.
In those cases, the government can tell a generating company how to operate, how to maintain their plants. It's like an emergency override switch for the power sector.
Unnecessary safeguard, I suppose.
Mm-hmm.
But what if that forces a company to operate inefficiently, costing them money?
The Act anticipates that. It allows the appropriate commission to step in and compensate the generating company for any adverse financial impact caused by those government directions. The commission figures out the fairest way to offset the losses.
So, emergency powers, but with a mechanism for fairness to the companies, a reasonable balance. Okay, let's move to licensing. The permits needed to play in the electricity game. How do you get a license to transmit power?
Right. Transmitting power usually needs a license. It's a process involving the appropriate commission. First, you apply.
Standard application?
Then the commission considers objections, they publish details, and people have 30 days to object. And crucially, if your proposed lines go near defense installations,
National security again.
yep, you absolutely need a no objection from the central government. That's non-negotiable.
Makes sense. What else is involved after applying?
The applicant also has to send a copy of their application to the relevant transmission utility, central or state. That utility then has 30 days to give its recommendations to the commission.
Recommendations. Are they binding?
No, not binding, just advice. The commission considers it, but makes its own decision. Before deciding, though, they also have to publish a notice about the application in newspapers.
More public scrutiny.
Exactly. They consider all suggestions, objections, and the utility's input before granting the license. It's a thorough process.
Sounds like it. Is there a time limit for the commission to decide?
The Act says they should try to decide within 90 days of receiving the application, either grant the license, assuming all rules are met, or reject it.
And if they reject?
They have to state their reasons in writing and, importantly, give the applicant a chance to be heard before the final rejection. Fair process.
Good. And once a license is granted?
The commission sends copies out immediately to relevant government bodies, the CEA, local authorities, anyone they think needs to know, keeping everyone informed.
Okay. Now, what if a licensee needs to change their license later, expand their network maybe, modify things?
That's possible. If the licensee applies for changes, they have to publish the proposed alterations, similar to the initial application process. And again, if it affects defense areas.
Central government consent needed. Got it.
Right. And the commission itself can also propose changes to a license.
Oh, the regulator can initiate changes too?
Yes. If they think a license needs modifying, they publish the proposed changes. And in either case, whether initiated by the licensee or the commission, they have to consider all suggestions and objections received within 30 days before finalizing any alteration.
So changes require transparency and input, regardless of who suggests them. Okay, now the flip side, license revocation. Taking it away, that's serious. What are the grounds?
It is serious, several grounds. One, if the licensee asks for it or consents. Two, if they break a license term that was specifically listed as a reason for revocation right from the start.
So read the fine print of your license.
Definitely. Three, if they fail to prove within a set time that they can actually do the job, fulfill their duties efficiently. Four, if they don't make required deposits, provide security, or pay their fees.
Financial and operational capability are key.
Absolutely. And five, if the commission believes the licensee is just too financially unstable to meet their obligations. And finally, there's a catch-all, public interest.
Ah, the public interest clause. Broad, but maybe necessary.
It allows the commission to act if keeping the licensee going would harm the public, even if other specific grounds aren't met. But there are safeguards.
Like what? They don't just pull the plug overnight, right?
No. They have to give at least 3 months written notice, spelling out the reasons. The licensee gets that time to respond, argue their case. The commission must consider that response before making a final decision.
Due process. Good. Are there alternatives to just yanking the license completely?
Yes. The commission can choose not to revoke, but instead allow the license to continue with modified terms and conditions, like putting the company on notice, basically.
A second chance, with stricter rules.
Exactly. It gives them a chance to fix the problems. But if revocation does happen,
What's the fallout? What happens to the power lines, the substations, the utility?
the commission issues a notice, sets an effective date. Then they try to deal with the utility. Usually they invite applications from others interested in taking over. The goal is often to sell it to the highest bidder.
Sell off the assets.
Right. The commission can compel the former licensee to sell. Once revoked or sold, the old licensee's rights and duties under that license end. Except for prior debts, those still stick.
They're out, but still liable for past issues. What about keeping the lights on during this transition?
Crucial point. The commission can make interim arrangements. They might appoint administrators to manage the utility temporarily, ensuring continued operation. No blackouts because of paperwork.
Absolutely vital. And when it's sold, the new owner.
The utility vests in the purchaser, free from the old licensee's debts specifically tied to it. Those debts attached to the purchase money instead. And the license itself, with its rights and obligations, transfers to the buyer. They become the new licensee.
So the new operator gets a clean slate with the assets. But what if no one buys it?
Good question. If it's not sold, the commission can issue directions or formulate a scheme for its continued operation, again, to protect consumers.
Yeah.
Or if the commission doesn't act, the former licensee actually gets the right to dispose of the utility themselves.
Interesting. Multiple backup plans. Okay, generation and licensing covered. Now the big one, moving the power. Transmission.
Right. Getting power from A to B, often over long distances. The central government plays a key role here. They can demarcate regions across India for efficient integrated transmission, connecting states, regions, building that national grid.
Drawing the map for the big power flows and managing this nationally, back to the National Load Dispatch Center.
Yep. Exactly. Established by the central government, they coordinate the scheduling and dispatch between the regional load dispatch centers. Crucially, they don't trade electricity themselves. They're the neutral operator, run by a government entity.
The Independent National Grid Controller and the Regional Load Dispatch Centers.
Also set up by the central government, one for each designated region, run by government entities too. Their job is complex. Optimum scheduling within their region based on contracts, monitoring the grid, accounting for power flow, supervising interstate lines in their area,
Lots of responsibility.
and real-time grid control for secure economic operation. They follow national grid standards and the regional grid code. It's like managing air traffic for a large slice of the country.
So regional control rooms coordinating with the national one. What about transmission purely within a state?
That's where the state commissions come in. They have to facilitate and promote interstate transmission, wheeling, interconnections, all aimed at efficient electricity use within the state.
And managing that state-level flow, state load dispatch centers.
Precisely. Set up by the state government. They're the apex body for integrated operation within the state. Their functions mirror the regional ones, but on a state scale. Scheduling, dispatch, monitoring, accounting, control over intrastate lines, real-time operation according to grid standards, and the state grid code.
Similar structure, different scale.
And they can levy fees on generators and licensees involved in intrastate transmission as specified by the state commission.
Okay, can they boss the power companies around within the state?
They have the power to issue directions for integrated, economic, efficient grid operation. And yes, licensees, generators, everyone connected must comply. Disputes go to the state commission, but you still have to follow the directions while the dispute is heard. Grid discipline is serious.
Real authority there. The Act also mentions directions from the appropriate government on transmission. How is that different?
Think policy versus operations. The load dispatch centers handle the technical how. The government, central or state, might issue broader policy directions, setting the overall strategy.
Got it. Now, circling back to the central transmission utility, what is that exactly?
The Act basically designates Power Grid Corporation of India Limited, the big interstate transmission player, as the CTU. Their job, handle interstate transmission and coordinate all the planning related to it, working with state utilities, governments, generators, regulators, everyone.
The central nervous system of the national grid.
Pretty much. And this is where open access for interstate transmission comes in again.
Right, letting others use those big national lines.
Exactly. Specified licensees and big consumers can use the interstate system. They pay transmission charges and a surcharge set by the Central Commission.
A surcharge? Why?
It's mainly to deal with existing cross-subsidies, where some consumers historically paid less, subsidized by others. The surcharge helps cover that, but the idea is to progressively reduce both the surcharge and the cross-subsidy itself over time.
Phasing out historical imbalances.
Right. But there's an exemption from the surcharge for captive generators moving their own power between their own locations in different states.
An incentive for self-sufficiency across state lines. Makes sense. Now, just like a central transmission utility, there are state transmission utilities.
Yes. The state government designates one could be the old state electricity board temporarily, or a state-owned company. Their role mirrors the CTU, but within the state. Intrastate transmission, planning, coordination with state-level players, ensuring efficient development of the state's grid.
The architects and managers of the state grid.
You got it. And, no surprise, there's open access in intrastate transmission, too.
Same principle, state level.
Pretty much identical. Specified players can use the state grid, pay charges, and a surcharge set by the state commission. Surcharge addresses state-level cross-subsidies, also meant to reduce over time. And again, captive generators moving their own power for their own use are exempt from the surcharge.
Okay, so open access is a key theme, nationally and state-wise, promoting competition, fair use. Now we've transmitted the power, let's get it to the end user, distribution.
Right, the final mile. The Act sets out the duties of a distribution licensee, your local power company. Their job, develop and maintain an efficient, coordinated, economical local distribution system and supply electricity according to the Act.
Build and run the local network, keep the lights on, simple enough. But open access applies here too, right? Maybe phased in.
Yes. State commissions had introduced open access and distribution, potentially in phases, within a year of a set date. It comes with conditions thinking about cross-subsidies, operational constraints on the local grid.
So practicalities matter.
Definitely. When setting the extent of open access and the wheeling charges the fee for others to use the local network, the Commission has to consider those cross-subsidies and grid limits. There's also a surcharge here.
Same reason, cross-subsidies.
Exactly. Meant to cover existing cross-subsidies at the distribution level, also supposed to reduce progressively. And captive power users get the exemption here too. Importantly, an amendment mandated open access for all consumers with demand over 1 megawatt within 5 years.
So bigger users definitely get choice eventually. What about safety standards for local supply?
That's the job of the Central Electricity Authority. They specify all the safety requirements for building, running, maintaining electrical plants and lines, right down to the consumer supply point. Safety first.
Absolutely. What about folks who aren't utilities but use a fair bit of power? Any rules for them?
Yes. If you're not a utility or licensee and you're transmitting or using power above 250 watts and 100 volts, you generally need to give notice before you start.
Notice to who?
7 days written notice to the local electrical inspector and the district magistrate or police commissioner. Details about your setup, power use, etc. And you have to follow safety rules. Exception for public transport power, though.
Okay, keeping tabs on significant non-utility power use. Finally, meters. Big deal for billing, right?
Huge. The Act mandates correct meters. After transition period, no distribution licensee can supply power without installing a proper, accurate meter meeting CEA standards.
Can they charge for the meter?
They can ask for a security deposit or charge rent unless the consumer buys their own. And the CEA can order meters installed anywhere. Generation, transmission, distribution, trading for proper accounting. Getting the numbers right is fundamental.
Absolutely. Accurate metering for fairness and tracking. Okay, we've followed the power to the plug. Now, the price. Tariff regulation. Who sets the price and how?
The Central Commission sets tariffs for interstate supply and transmission. But the principles guiding tariffs apply to all appropriate commissions, central and state.
And what are those principles? Can't just be random numbers.
Definitely not. Key principles. Consumer interest is paramount, but also the financial health of the power companies, generators, and licensees. Everything should run on commercial principles, encouraging competition, efficiency, good performance, smart investments.
The balancing act, then. Consumer price versus company viability.
A very tough one. They also have to ensure reasonable cost recovery for companies, reward efficiency, use multi-year tariff outlooks where possible, and crucially, tariffs should gradually reflect the actual cost of supply, meaning those cross-subsidies need to shrink.
Phasing out subsidies embedded in the tariff.
Right. Plus, promoting cogeneration and renewables, and everything has to align with the national electricity policy and tariff policy. It's a complex mix of goals.
Sounds like it. Any special rules during power shortages? Prices can go wild then.
Yes, the Commission can step in during shortages and set price caps and floors for short-term power sales, less than a year. Prevents extreme price gouging when supply is tight. Guardrails for the market.
Smart. What specific tariffs do the commissions actually determine?
Generation tariffs, transmission tariffs, wheeling charges, and the final retail tariff paid by consumers. Though in areas with competing distribution companies, they might just set a maximum retail price, a ceiling, to let them compete below that.
Fostering competition by setting a cap, not a fixed price. Can they demand detailed financial info from companies to set these tariffs?
Absolutely. They can require generators and distributors to provide separate detailed financials for each activity: generation, transmission, distribution, specifically for tariff setting. Transparency is key.
Definitely. The Act also says no undue preference in tariffs, meaning
Basically can't unfairly favor one consumer group over another, but they can differentiate based on valid factors.
like what kind of factors?
Things like load factor, how consistently you use power, power factor, how efficiently, voltage level, total consumption, time of use, day-night rates, geographical location, nature of supply, and the purpose of use, industrial, agricultural, residential, etc. Those are legitimate reasons for different price structures.
So logical differences are okay, arbitrary favoritism isn't. How often can tariffs change? Can my bill jump every month?
Generally, no more than once per financial year. The main exception is for adjustments under an approved fuel surcharge formula. That lets companies pass through significant changes in fuel costs, like coal or gas, without a full tariff review each time.
So some stability, but with flexibility for fuel costs. How does the Commission issue a final tariff order?
They can accept the tariff application as is, accept it with modifications, or reject it. If rejecting, they must give written reasons and let the applicant be heard first. Due process again.
And once issued, is the order public?
Oh yes, copies must be sent within 7 days to government bodies, the CEA-affected companies, and anyone else directly impacted. It's public record.
Good. Now, there was a mention of state commissions setting tariffs for some interstate deals. Isn't that usually the Central Commission's job?
It's a specific exception. If both parties in an interstate deal, say, a generator in one state and a distributor in another, agree, they can jointly ask the state commission where the buyer is located to set the tariff for just that specific transaction. Offers flexibility.
Interesting niche case. How long does a tariff order last?
For the period specified in the order, unless it's amended or revoked earlier, they have defined lifespans.
Okay. Finally, on tariffs. Subsidies. State governments can subsidize certain users, right? How does that work?
Yes, they can subsidize tariffs set by the state commission, maybe for farmers or low-income homes. But here's the crucial bit. The government must pay the full subsidy amount in advance to the affected power company.
Pay up front.
Yes. The company only has to implement the subsidized tariff after receiving the payment. Ensures the utility doesn't bear the cost of the government subsidy policy.
State puts its money where its mouth is. Fair enough. Okay, tariffs navigated. Let's look at the Central Electricity Authority, the CEA. What's their role? Sounds like the technical backbone.
That's a good description. The CEA is the primary national technical expert and standards body for the whole sector, hugely important for safety and reliability.
So what are their main jobs? What do they actually do?
A whole range of things. Setting technical standards for grid connection, specifying safety requirements for all electrical plants and lines, defining the grid standards for operating transmission lines reliably, specifying conditions for meter installation.
Setting the engineering and safety rulebook.
Exactly. They also promote timely completion of system improvement projects. They publish information and reports. They encourage research in electricity. They can conduct investigations.
Busy folks.
Very. They advise governments, licensees, generators on improving operations and coordination. They give technical advice to the governments and the regulatory commissions, and basically any other technical function assigned by the Act. They're involved everywhere, technically speaking.
A massive technical scope. Do companies have to give them data?
Absolutely. Licensees, generators, even captive generators must provide stats, reports, info on generation, transmission, distribution, trading, use. Whatever the authority needs, in the format and time they specify. They need data to monitor the sector.
Data is power, even for the regulators. Is the CEA totally independent?
It's an independent statutory body, yes. But the Act says it is guided by written directions from the central government on policy matters involving public interest. If there's a dispute about whether something is a policy matter, the government's decision is final.
So policy guidance from government, but technical operations are the authority's domain. Okay, that's the CEA. Now, the regulatory commissions, CERC and CERCs. The rulemakers and judges, let's start with the central one, CERC.
Right, the Central Electricity Regulatory Commission. It's established by the Act. It's a body corporate, perpetual succession, can own property, sue, and be sued. The independent national regulator.
And who sits on the CERC? What's their expertise?
A chairperson and 3 other members. They need expertise in relevant fields. Engineering, power systems specifically, finance, economics, commerce, law, or management. But there's a cap. No more than 1 PAL. Member from economics, commerce, law, or management combined. Ensures a strong technical base.
Skewed towards engineering and finance, it seems. How are they picked?
The central government sets up a selection committee. It recommends names for the appellate tribunal and CRX members. Includes folks from planning bodies, law ministry, public enterprise selection board, other experts. They suggest a panel of 2 names per vacancy. Rigorous process.
Sounds like it. In mirroring this nationally, we have state commissions, SCs.
Yes, each state government sets up its own ESSER. Similar powers and functions, but within the state's boundaries. Also body, corporate, etc.
What about multi-state issues or union territories?
The Act allows for joint commissions, formed by agreement between states or between the center for UTs and states. The agreement spells out the details: name, selection, office, cost sharing. Interestingly, even a joint commission sets tariffs separately for each participating state UT.
Regional cooperation but local pricing. Who qualifies for a state commission? Similar criteria.
Yes. Meetability, integrity, reputation, plus knowledge in engineering, finance, commerce, economics, law, or management. A state can also appoint a high court judge, current or former, as chair after consulting the Chief Justice. And like CERC members, they can't hold other paid jobs.
Focus on expertise and independence. How are they selected? State-level committee.
Yes. State government sets up a selection committee, usually chaired by a former high court judge, includes the state's chief secretary, and either the CEA chair or CERC chair. Blends judicial, administrative, technical input.
Similar principles. Okay, what do these state commissions do? Key functions.
Huge role at state level. Number 1, regulate retail electricity tariffs within the state. That's the price we pay.
The big one for consumers.
Also regulate how distribution companies buy their power. And very important now, facilitate renewable energy growth, grid connection rules, purchase obligations. They drive the green shift locally.
Pushing renewables. What else?
They adjudicate disputes between licensees and generators in the state, or refer them to arbitration. They set the state grid code, promote energy efficiency, encourage investment and restructuring in the state's power industry, and handle other matters referred by the state government. Broad oversight.
Regulatory and quasi-judicial role. Are they bound by national policies?
Yes, explicitly. They must be guided by the National Electricity Policy, National Electricity Plan, and National Tariff Policy. Ensures some consistency across India.
Good. Do they get feedback from stakeholders, advisory committees?
Yes, they can set up state advisory committees, up to 21 members representing industry, commerce, agriculture, consumers, NGOs, academics, a wide range, chaired by the SRC chair, a formal way to get input.
Mechanism for stakeholder voice. Now, the members themselves on both central and state commissions, terms of office, rules.
Generally a 5-year term. Not eligible for reappointment to the same post in the same commission. Age limit is 65. Salary and conditions set by the respective government and can't be changed to their disadvantage after appointment. They take an oath of office and secrecy.
Standard stuff for high office. What about resignation or removal?
Can resign with 3 months' notice. Removal is possible for specific reasons. Bankruptcy, serious criminal conviction, incapacity, conflict of interest, abusing position, proven misbehavior.
Curious grounds.
Yes, and for conflict of interest, abuse, or misbehavior, it usually requires an inquiry by the appellate tribunal chair first, unless they're a judge. Government can suspend them during the inquiry. Safeguards for integrity.
Clear procedures. What legal powers did these commissions have during hearings?
Powers like a civil court. Summoning witnesses, demanding documents, taking evidence via affidavits, requesting public records, issuing commissions for witness examination, even reviewing their own decisions sometimes. They can issue interim orders, authorize consumer representation, and even enter premises to seize relevant documents under proper procedure. Essential powers for effective regulation.
Quite a bit of clout. Needed for the job, I guess. Now, if you're unhappy with a commission's decision, where do you appeal?
That's the job of the Appellate Tribunal for Electricity, set up specifically to hear appeals against orders from adjudicating officers or the commissions, SEERC or SERCICs, the next level up.
The Electricity Appeals Court. Time limit to appeal.
Generally 45 days from the order date, but the tribunal can allow later filing if there was a good reason for the delay. Some flexibility there.
And once appealed, what can the tribunal do?
They hear all sides. Then they can confirm the original order, modify it, or set it aside completely. They send copies of their decision back to everyone involved. They're supposed to aim for disposal within 180 days. Quick resolution is the goal.
Push for speed. Can they act on their own without a formal appeal?
Yes, they have suo motu power. They can call for the records of any commission or adjudicating officer case, review it for legality and propriety, and issue orders as needed. An oversight function.
An important check. How is the tribunal structured? Who's on it?
Chairperson plus 3 other members. Work is done in benches, each needing at least 1 judicial member, high court judge level, and 1 technical member, sector expert, usually based in Delhi but can sit elsewhere.
Mix of legal and technical again. Qualifications for appointment must be high level.
Very. Chair needs to be Supreme Court judge or High Court Chief Justice, current or former. Members can be High Court judges, senior government secretaries, a connoisseur background, or people with 25+ years of high-level experience in electricity, regulation, economics, commerce, law, or management. Top-tier expertise.
Definitely. How do they run proceedings? Strict court rules.
Not strictly bound by the Code of Civil Procedure. Guided by principles of natural justice. They can regulate their own procedure. But they do have civil court powers for things like summoning witnesses, getting documents.
Legal muscle, procedural flexibility. Can you bring a lawyer?
Absolutely. Appellants can appear themselves or use a lawyer. The commission being appealed can also send lawyers or officers to present their case. Legal representation is standard.
And is the tribunal's decision final? Or can you go higher?
You can appeal further to the Supreme Court of India, but only on specific grounds, essentially substantial questions of law. And you have 60 days to file, extendable by another 60 for sufficient cause. So the highest court weighs in, but only on significant legal issues, not just re-arguing the facts.
Ultimate arbiter on points of law. Okay, dispute resolution covered. Now, what happens when rules are broken? Offenses and penalties.
Right, the consequences section. A big focus is on theft of electricity. Covers a lot more than just hooking a wire illegally.
Like what else? Meter tampering.
Exactly. Dishonest connections, yes. But also tampering with meters, using tampered meters, devices interfering with readings, damaging meters to stop them recording, or even using electricity for a purpose you weren't authorized for.
Using residential power for a factory, maybe?
That kind of thing. It's all theft under the Act.
What are the penalties for theft?
Depends on the load. 10 kilowatt or less.
Yeah.
First offense, fine at least 3x the financial gain. Second offense, fine at least 6x the gain. Over 10 kilowatts, first offense, fine at least 3x the gain. Second or subsequent offense, mandatory minimum 6 months jail, up to 5 years, plus fined at least 6x the gain.
Jail time for repeat large-scale theft.
And repeat offenders over 10 kilowatt can also be disconnected from any supply for 3 months to 2 years. Serious stuff.
Definitely. Can the power companies investigate suspected theft?
Yes. Authorized officers, designated by the state office, can enter, inspect, search premises if they suspect unauthorized use. They can seize devices, wires, meters used for theft. They can also seize relevant account books, allowing copies to be made. Follows criminal procedure rules with limits on night searches of homes.
Investigation powers with safeguards? What about theft of electric lines and materials? Stealing the infrastructure itself?
Separate offense. Dishonestly cutting, removing, transferring lines, materials, meters from installations or storage. Punishable by up to 3 years jail or fine or both. Repeat offenses get harsher minimum jail terms.
Protecting the gear, too. What about handling stolen power lines or materials?
Also an offense. Dishonestly receiving stolen electrical lines, materials, knowing they're stolen. Up to 3 years jail or fine or both. Can't deal in stolen grid parts.
Okay. What about interference with meters or works of licensee? Messing with the system.
Covers unauthorized disconnection of meters, reconnecting after being cut off, unauthorized communication with utility systems, deliberately damaging meters, altering readings, stopping registration. Up to 3 years jail, fine, or both, plus daily fine for ongoing interference.
And there's a presumption if the means exist.
Yes, if the means for interference exist and the meter is under the consumer's control, it's presumed they did it knowingly unless they prove otherwise. Burden can shift.
Important point. Penalties for just damaging works. Negligently or intentionally?
Yes, negligent damage, fine. Intentionally damaging lines works to cut off supply. Also a fine. Don't mess with the infrastructure accidentally or on purpose.
Good advice. What if you just ignore an order under the Act or break some other rule? General non-compliance.
Failure to comply with orders directions or contravening other provisions rules, up to 3 months jail, or fine up to 1 lakh rupees or both. Plus daily fines if non-compliance continues after conviction. Broad enforcement power.
So, follow the rules or face consequences. Are these penalties in addition to other liabilities?
Yes. Penalties under this act don't preclude other legal actions. If you damage property while stealing power, you could face act penalties and a civil suit for damages. It's not an either-or.
Doesn't cancel other laws. Does this apply to government-owned systems too?
Yes, explicitly. The Act's provisions, including offenses and penalties, apply to government supply and works as relevant. No free passes.
Accountability for all. What if a company commits an offense? Who's liable?
The company itself, and every person in charge of and responsible for the business at that time. Directors, managers, secretaries too, if the offense happened with their consent or knowledge, or due to their negligence. Leadership accountability.
People at the top can be held responsible. What about helping someone else commit an offense? Abetment.
Punishable as if you committed the offense yourself. Specifically, if a utility employee agrees to commit or conceal theft or facilitates it, they face penalties. Same for electrical contractors or workers helping with theft. They can even lose their license. Can't enable wrongdoing.
No turning a blind eye. How do these cases get to court? Who files the complaint?
Generally, courts only take notice based on a written complaint from the government, commission, authorized officer, electrical inspector, licensee, or generator. However, they can also act on a police report filed under normal procedures, and the special courts can take notice directly.
So usually initiated by affected parties' regulators, but police can be involved. What powers do police have?
Standard investigation powers under the Code of Criminal Procedure. Importantly, theft of electricity and related offenses are classified as cognizable. Police can investigate without warrant. And non-bailable, bail isn't automatic, shows the seriousness.
Treated as serious crime, can these offenses be settled out of court? Compounding.
Yes, for theft of electricity. The government or an authorized officer can accept a sum of money, rates specified in the Act, vary by consumer type, from the offender. This compounds the offense.
What happens then?
If paid, the person in custody is released. No further criminal proceedings are taken for that offense. It's treated as an acquittal. But it's a one-time deal per person consumer. Can't keep doing it.
One chance to settle. To handle these cases, there are special courts.
Correct. State governments set them up with exclusive jurisdiction for act offenses, especially theft. Judges, appointed by state government, regular courts must transfer relevant cases to them. Specialized handling.
How do these special courts work? Same as regular courts.
They follow the Code of Criminal Procedure generally, but with differences. They can conduct faster summary trials for some offenses, still up to 5 years jail possible. They must also determine the civil liability for theft, at least twice the tariff rate owed recoverable like a civil court decree.
Dual criminal and civil role.
Exactly. They're deemed courts of session. Appeals go to the High Court. They also have limited review power, designed for efficient handling of electricity offenses. Okay, that covers the teeth of the act. Almost done. Dispute resolution beyond appeals arbitration.
Yes, for matters directed to arbitration under the Act. Generally follows the Arbitration and Conciliation Act 1996, unless the license specifies different arbitration rules than the license rules apply. The Commission can nominate arbitrators if asked, an alternative route for some disputes.
Alternative to court. Finally, other provisions, the catch-all section. What's key here? Lots of important bits. Protective clauses for railways, highways, airports, etc. Electricity work shouldn't harm or obstruct them. Rules for preventing interference with communication lines. Powers of electrical inspectors for accident inquiries and safety compliance, like a civil court. Appointment and powers of inspectors, plus appeals against them.
Safety and coordination.
Right. Licensee's right to enter premises for inspection repair, with notice. Status of Tribunal Commission members as public servants. Recovery of unpaid penalties as land revenue arrears, strong enforcement. Rules for serving notices, transitional provisions for old electricity boards, government power to grant temporary exemptions from the Act.
Lots of administrative glue holding it together.
And finally, lists of specific matters on which the Central Government, CEA, Central Commission, State Governments, and State Commissions can make detailed rules and regulations to implement the Act, filling in all the operational details.
Wow, okay. That really was a deep dive. We've covered a huge amount of ground on the Electricity Act 2003, from definitions to generation, transmission, distribution, tariffs, regulation, penalties, the works.
It's genuinely striking just how comprehensive this legislation is. It's trying to manage an incredibly complex system, balancing so many different interests. Consumer needs, company viability, the push for renewables, grid stability. It's a massive undertaking.
Absolutely. And hopefully this journey has given you, our listener, a much clearer picture of how electricity is regulated in India without getting totally bogged down in legalese. We aimed for the key insights, the relevant stuff, your shortcut to being informed on something vital.
Definitely. You know, one thing that stands out is that constant thread of balancing tight regulation with trying to encourage competition, especially through open access. It really makes you wonder.
What's that?
Well, looking ahead, how effectively can this framework, designed in 2003 with amendments, really adapt? Think about the pace of technological change now. Smart grids, storage, EVs, distributed generation, plus the huge push for sustainability and India's growing energy demand. How will this act cope with the future?
That is a fantastic question to leave our listeners with. How does this 20-year-old framework square with the energy transition that's happening right now? Something to chew on. If any part of this sparked your interest, definitely dig deeper into the Act or related topics. There's always more to learn.
For sure. Until our next deep dive.
Keep those mental circuits charged.